This was all my idea, Judge. I'm a little offended Mr. Denver is trying to give someone else credit.
All right, let me stop you right there, Mr. Delfino. Without concrete evidence of your theory, the law says Miss Atwood's private communications cannot be subpoenaed.
I have evidence. You just didn't let me get to that part.
Get it, Frank.
This is the victim's morgue transfer sheet, signed by an investigator hired by Miss Atwood's office, Nate Leahy. This is proof Mr. Leahy moved and hid the body from Miss Atwood.
Mr. Leahy does not work on this case, Judge.
He's Miss Atwood's boyfriend. Doesn't that matter?
Is this true, Miss Atwood? You have a romantic relationship with Mr. Leahy?
We were at some point, but it ended before this case.
Were you aware of such a relationship, Mr. Denver?
But the DA's office imposes no restrictions on its staff regarding workplace relationships.
Mr. Delfino, though ill-advised, ADA Atwood and Mr. Leahy broke no laws.
What about the Sixth Amendment? That's the one that says every defendant has the right to a fair trial, correct? But what's happening here? The prosecution's tampered with evidence, showing bias, not to mention they got tons of conflict of interest. That's the opposite of fair. It's just a damn subpoena, Your Honor.
Watch your language, Mr. Delfino.
Sorry.
But you did hit on a valid point. Mr. Delfino is correct in that even just the appearance of bias can waive the DA's protection from disclosure.
Only in extreme cases, Judge.
I find this to be one of those. I'm granting the subpoena. Miss Atwood, you are hereby ordered to turn over your emails, calls, and text messages for the day the body was transferred.